Yeah, the website won't work either because we've already started the meeting.
Oh.
Oh, here, I just figured it out.
Who's doing the thumping? Our last meeting, it was just a work session, right? On the 5th?
Correct.
Do we actually have, do we count the work session? Do we still have formal adoption of the minutes?
I don't know the answer to that question. I would think so.
Just go ahead and do it.
I mean, the board still met, so there should be a record of the fact that the board met. As you know, you had an open meeting.
Okay, so there's no harm if we do it then, right?
Correct. Definitely no harm.
Okay.
Did you want me to propose something, Ed?
I'm still waiting for Judy, but.
Oh, that's right. That's right.
But I was just going through my head, absent
Good
of
idea.
a formal agenda, what needs to be done.
Good idea.
And when I started thinking about it, I realized 2 weeks ago seems like a couple decades, and I wasn't even sure what happened.
Okay, Erica, can you text Tootie and tell her to go to the website to howardcountymd.webex.
Okay.
howardcountymdwebex.com. I'm sorry, that's how it goes. And then the number she'll have to put in is 180. Sorry. It'll come up. It'll ask for a meeting number.
Okay, 180.
831 7681. Actually, I'm going to put this in the chat for you so you can see.
Oh, thank you. 7681. Okay. Howard County MD. .webex.com.
Correct.
Thanks for your help, you guys. Sorry.
Oh, there she is.
Hi, everybody. So lesson learned, if you sign in and sign out, it's very confused.
You're screwed.
I apologize.
Yeah,
Actually, Judy, that's happened to me before, so that's not
Yeah.
an anomaly.
I used to do it all the time, actually. Yeah.
Uh, okay, let me get the live, in the middle of all that, the live streaming setup wasn't working well either.
So that's a bonus.
Oh, Ed, love the shirt. Love it. Love it. I must say, it is pretty cool to not have to be out tonight, right?
Yeah, good point.
The best.
Yes, I thought about that this afternoon.
Or worse yet, having to drive home later tonight. Ooh, bad.
But traffic has been so much nicer, it's okay, you know?
Okay, I think. Nope, it says okay.
Was that an okay?
Yes, okay, you can go ahead.
Okay. Welcome to the Howard County Planning Board meeting of December 17th, 2020. Tonight is continuation of the work session for writing a draft, the rules of procedure. Right now, what we're trying to do is we're working through a draft, and when we complete this, it will be posted for public comment for at least 30 days, and then there will be a opportunity for a public hearing at the end of that. Could I have a motion to approve the minutes from our last meeting?
Sure. I move that the video recording of the December 5th, 2020 Planning Board work session be submitted as our minutes.
Second?
Phil, second. All in favor?
Aye.
Aye.
Okay, it's unanimous. So I think we left off on page 4, although I am willing to be corrected on that.
I took a note on that. It was actually page 7, section F.
7, okay, wow.
Yeah,
I think it was 15, actually. 15, yeah.
And then, so Lisa or somebody was going to share their screen of where we're at.
I'll put them on.
So Mary, can you share your screen and put it up, or who's going to do it?
Yeah, I think, Lisa, are you having technical problems right now?
Yes, for some reason, I can't do 6 things at once like I normally do. I just made you presenter.
Okay. Right. There we go. All right. Page 7, section F. Types of meetings. All right. So Ed, do you just want me to scroll to the sections where there are edits for, because remember, you proposed a kind of a bit of a reorganization to the rules of procedures. Now it's organized in sections that are kind of more common to meetings as a whole, within each section then how there are distinctions between different types of meetings and hearings. So it looks like this section has the types of meetings. You're getting into the distinction between a public meeting versus a public hearing. Ed, are you talking? You're on mute.
I wondered why nobody was responding to me. Did anybody have any changes to the section that said F, public meetings? Types of meetings? No? Okay. So, F.1, public meetings. I have a question about that last paragraph. There's all kind of places where we talk about time limits and other things. And I would think that we'd either want to reference those or just delete that last sentence. Because otherwise, I could see people wanting to argue what it means by reasonable opportunity. Does anybody else feel that way?
Yeah, who decides whether it's reasonable? Would that be the chair?
I don't want it to be me. You know, I don't want to have that argument.
I mean, if I may, as a first cut, it's going to be the chair. I mean, it's ultimately the board. But yes, what the board decides is reasonable is what's reasonable. It's not up to the participant whether the board is giving it a reason. They may disagree, but it's ultimately up to the board.
Should it say reasonable opportunity from the board or by the board?
You could say the board shall give a reasonable opportunity.
Okay, yeah, that gets Ed off the hook.
Or shall be given a reasonable opportunity by the board.
Yeah.
I like that by the board.
That establishes who is the decider.
Right.
As determined by the board, because that makes it even clearer.
Great.
Okay, and then
Put the
anybody
comments
else have
in. Yeah.
anybody else have comments? So for public hearings? Public hearings? So if there's no change, is there rules of evidence?
Oh,
Go
and
ahead.
just wanted to, this is just for conversation. I know I've seen other boards where when we're looking at the public hearing and also thinking about some of our public hearings in the past. I mean, obviously the chair and the board can change time, but there's been like a time limit. I don't know if that's something we would want to, it would make it kind of stringent, but something I just wanted to throw out there for the public hearing.
If you limit a party's presentation or given witness testimony strictly, you can have time goals, but the limiting factor on testimony is is relevance and non-repetition in effect.
Okay.
And if you set a hard cap time limit, you're potentially requiring someone to stop before they've actually had a full opportunity to address an issue.
Okay.
That doesn't mean, in fact, it doesn't even have to be in your rules. You could address a party by, asking them, how much time do you need? Can you do it faster if they give a time that's too long? If they say, I need the whole night, how about 15 minutes? Can you get it done in 15 minutes? But the ultimate factor, the ultimate determination, so they don't have in your hearings, you give them 3 minutes.
Right.
And you let them say sort of whatever they want for 3 minutes. Testimony it needs to be relevant and needs to not be repetitious. So if 1 minute into their testimony, they're testifying about something unrelated to what the board has to decide, or they're simply saying the same thing over again, their testimony could be ended right then. They don't have a right to go on. On the other hand, as I said, as long as they're saying something that isn't repetitious and that is relevant, it's problematic to cut them off simply because they've had to go on for an extended period of time.
So, Mr. Moore, you're saying basically the chair could, if they're going off topic or the chair can make a discernment?
It's easier for the chair when somebody objects, and sometimes your opposing parties just let them go rather than object because maybe they figure it's easier to let them burn out than it is to cut them off. But the chair can interject. The board has an interest in testimony being limited to relevant material, because if your record is filled up with irrelevant testimony, there's a danger of a reviewing body reaching the perception that the board decided the case on something other than relevant testimony. Because look, you had hours of irrelevant testimony. That must have influenced you because it was all opposed or it was all in favor. And that's what you did. So the board has a self-interest in keeping testimony limited to what is relevant, in addition to the fact that it doesn't help you if it's not relevant, because you can't base your decision on it. But there is some degree of appellate risk that it could create the perception that because you allowed so much of that, then maybe you were considering it and you weren't allowed to consider it because it wasn't relevant. So the board can on its own cut that off, yes.
But the board has, the relevancy of a given. I can think of an occasion specifically where they've just kept asking questions, but it seemed irrelevant. And then when I brought that up, he said, well, no, I'm getting to that. And then it went on and on and on. An inordinate amount of time. But the board still, or the chair would still have the opportunity to just cut it off. In other words, I can say this is relevant and it's not at all.
It's the board's judgment, right? It's the board's determination whether it's relevant.
Okay.
And how you handle that is a discussion. We can have now if you want, or I can have it with any one of you individually offline if you want, because it doesn't have to be in the rules.
Mm-hmm.
There are tactics that, for example, judges would often use to do the exact same thing that the board's called upon to do. One version of that can be when they say, I'm getting to it, you can ask them, well, what is it you're getting to? Can you offer to me where we're headed? Because if it turns out that where we're headed isn't relevant, there's no need to go on further. There's a number of ways to do that. I'm sure a lot of you have spotted them or carried them out on your own already, but I'm happy to talk about it. But I wouldn't necessarily suggest it belongs in the rules how to do that. Mm-hmm. I was just interjecting, and I apologize if I interrupted, to note that
that's why I kind of threw it out there. So thank you, Mr. Moore.
Mm-hmm.
So actually, if you scroll to the rules of evidence, that last sentence kind of is saying what you're saying, but it just says evidence instead of testimony. Should we maybe pull that up and have it include testimony? Testimony is evidence, but I'm wondering if putting it higher where the testimony is talked about would strengthen its impact.
I think this is adequate the way it is, but It speaks to what my concern would be.
But so Erica, that was the point you were trying to make, isn't it?
Yes.
So are we want to move on, or is there still discussion?
I see what you mean, Ed. You're thinking that we should move it up instead of it being just under rules of evidence, actually move it under the first heading under public hearings, somewhere in that paragraph, or make it as, yeah, instead of it being hidden down under rules of evidence, talk about what your testimony can be, should be up above.
Can it appear in both places?
Sorry, somebody needs to repeat.
I said, can it appear in both places, or is that repetitive? Because it's a worthwhile thing to put in there, because I think it would helpful for a future board to understand where the barrier, where you can draw I guess draw an end to a way that the testimony is kind of spilling out. It's a good sentence there.
So how about under public hearings, where it talks about the meeting format, including provisions for witnesses, witness cross-examine, and opposition to provide presentation and witnesses, we copy and paste that sentence and put it there, and then change the word evidence to testimony. So if you
Changing evidence to testimony?
yeah, right now, if Mary, if you would just copy and paste, grab that sentence.
Is it the board shall exclude immaterial evidence and may?
Yeah, all the way to the end. So just copy that, and then scroll up, and then after where it's A, witnesses, B, witnesses, presentation and witnesses, at the end of that, just paste it in there. And then we can change evidence to testimony. How does that work for you?
I'm just reading.
Yeah, and probably that and other evidence needs to be deleted. Yep, there you go. Read my mind. Is that okay?
I think that.
Yes, I like that.
Yeah, I agree.
And then after cumulative in nature, it's a new paragraph for the public is invited. Yep. Good idea, Ed. Good idea, team.
That was Erica.
Do you
Okay.
think the board shall exclude or the board can exclude?
Can.
Sorry, please.
Should not be shall.
if I understand what Mr. David had just said, we kind of are obligated to do that so that we don't get into the situation where you described where we're deciding on things that are immaterial.
I guess I would say that if you want to leave yourselves the discretion, you can do so. It's advisable to avoid irrelevant or cumulative testimony, especially irrelevant. But it's your call. I mean, you could make it mandatory. I guess the limited risk of making it mandatory is that someone could challenge your decision on the basis that you violated your rules because you let in irrelevant testimony, even though your rules say you shall not do so. I don't think that's a terribly big risk because they could challenge your admission. They could challenge your allowance of irrelevant testimony anyway. It's just slightly higher, I suppose, if you say shall, because then you've actually got a rule that mandates you exclude it.
Yeah, I'd leave it at can.
How about the word may?
May is permissive. I mean, can describes your power to do so. May says what you may or may not do.
All right, I vote on can.
I agree.
I agree.
Okay, can it is.
In reference to immaterial evidence. Oh, it is may exclude undue favor. The word may is used here.
Okay, moving to rules of evidence. Any changes for the witnesses? Is that feedback coming from me?
I don't know.
No, it's just too many microphones open. So if you're not speaking, you should mute yourself. It just seems to be very touchy tonight.
Okay, so does anybody have any comments on this? I think this stuff was all basically what we had previously. No comments?
I think it's fine.
Okay. So,
You should put your video back on, Ed, so we can see you.
okay, I was hoping that was going to help things.
You know,
But-
shirt and all.
Yeah, well, you know.
Ed, I do have a question about the going into closed work session, just based on one of the issues that I had, and Mr. Moore may be able to help. Now, isn't there a form for closed work session?
There is. There's a form required by the Open Meetings Act. That you've been, which you all have been filling out.
Do you think that needs to be mentioned, or are we okay based on the fact that they're saying the Open Meetings Act?
There's no harm in including it. It's not, I mean, the form's required whether it's in your rules or not. Where it's required where required. So to the extent that you bring up sort of the educational purpose for future boards, I suppose it has that benefit. Although
that's what I'm thinking, just to help those who are coming in after us.
So I think my preference was to just quote the Open Meetings Act, so that if it ever changed, we did not need to change the rules. We would just follow whatever their procedures were.
Okay, that would work. That way it would give leniency if, like you said, if things changed.
The and maybe we could have a uh, I don't know, something that's separate from the rules of procedure that we could change on the fly, that it'd be like our handbook or notes or something. I don't know what its exact form would be, but um, I don't know. It's something else that I had thought about, but I don't know how to present it.
Are you talking about some sort of educational pamphlet for the board members?
Well,
A cheat sheet.
still part of it was like when it comes time to tell people how to sign up and what like client that we're using and things that are likely to change. Like if for some reason you stopped using WebEx and you went to Microsoft Teams, those instructions would change. So I wouldn't want those instructions embedded in the rules of procedure, but they should be accessible on the website as instructions to what people are doing. And along with that, maybe there'd be an amendment or an amendment with like how we conduct things, what it means to be the Open Meetings Act. Maybe it's a FAQ section for open meetings,
FAQ. Good idea.
right?
FAQ.
You know, and somewhere in there that we talk about the form and the reasons why of whatever they are, but something that doesn't take a lengthy review period to change. It's just things that we have to be following that night, if that makes sense, and if that's legal.
I have a question. Mr. Moore says we've been filling out this form. Is that an administrative responsibility that is maybe done by staff there, that they are making sure that we are in compliance?
For the last one that we did, Lisa sent it to me and I filled it out and then sent it back.
So it doesn't necessarily need to. So it is an administrative kind of an oversight by staff that board members may not necessarily be responsible for knowing. Sounds like it's already been taken care of.
I would classify it as it's a responsibility of the board that's handled by the chairman.
But Lisa's out.
And the education issue is going to be addressed by the fact that at least one of you, and probably more than one of you, has to take the Open Meetings Act training anyway.
I have, and Phil's going to.
I mean, it's available online.
Yeah, I looked it up earlier. It's under the it's the Attorney General website. If you just search for Maryland Open Meetings Act, it's a couple clicks away. Who's ever typing, would they please mute the mic? Thank you. So any questions or any comments on rules of evidence? Witnesses? Work sessions? Okay. G, time limits? Okay.
Did we indicate on written testimony, did we change, were we comfortable with 1 day in advance of the meeting? Number 3, written testimony.
The I think there's some pushback if we try to make these deadlines too much farther ahead. And if it's, in my mind, if it's just a page of what they're going to talk about, then that's less of a time sensitive thing. I mean, getting that the day of it is acceptable to me. I don't know how you guys feel.
Well, it's certainly better than being handed a pile of papers while you're in the meeting. I just thought maybe before with a little bit more time, but that's fine.
1 day in advance would be great. Sometimes, you know, you look at everything around noon and you see nothing. You don't go back in until an hour before the meeting, and all of a sudden there's a stack. Uh-oh.
Would it help if we also include their it's you can submit it early?
I certainly do think so. I would love to have things earlier if possible. I think that would be very helpful.
1 day or...
Well, I think this should include that you know, the 1 day in advance sounds like you don't have to do anything until just throw it in there 1 day in advance. And then is it the end of business on the day prior, or is it the beginning? Or is it 24 hours? You know, what are we talking about?
1 or more days in advance?
Well, yeah, 1 or more. I mean, to me, it would be nice to encourage getting the materials to us sooner than within the 24-hour period.
So how about if it said, like, the board at its discretion may accept written testimony by email, facsimile, may be submitted early and or is due at least 1 business day in advance?
Yeah, I mean, I guess that would work, yeah.
I guess you could say no later than 1 day in advance.
That might be better for me.
No later than 1 day in advance.
Yeah, that indicates you could do it a week ahead of time if you were organized.
Yeah, I kind of like emphasizing, though, that they can submit early.
Yeah.
That word early in there. But
you can say may accept it early and no later than 1 day in advance.
That works right there.
Yeah, or earlier. Yeah, that's fine.
I think the way it's written right now is a little confusing because it seems to say no later than 1 day in advance or earlier. I presume what you're trying to say is the board may accept written testimony at any time and in no event later than 1 day in advance. I mean, or maybe you just want a separate sentence after that where the board, leave it as it is, no later than 1 day in advance of the meeting, and then say the board encourages submittals as early as possible. Because I'm guessing the people who would push back are going to be ones who they have to wait for their community group to meet and vote, and that meeting gets scheduled, you know, 2 days before your meeting, and so they can't do it further than that.
Yeah.
What you're trying to do is tell them we appreciate it as early as possible.
Yeah, I think a little bit of that might go some way. I mean, obviously, if people are using it as a tactic to throw us off our game, they're going to do that anyway. So it would, yeah.
Did you say as early as possible? The board encourages submittals as early as possible,
Okay.
I like that.
or just the board encourages early submissions.
As early as possible. I mean, it sounds like, it would really help their situation. I don't know.
So that's good. We can come back later if somebody wants to wordsmith it some more.
That looks good.
Looks good.
So planning board authority. I think this was all from before. There's no changes in here. No comments? And the intent of this was the same chart that we used to have, but instead of going across the page, it goes down the page. And I hope that this made it a little bit easier to read. It should be the same content.
Definitely easier to read this way.
I agree.
And then next, everybody's favorite, quasi-judicial then. Oh, but go back to the chart a little bit. We might want to think about putting a section in this chart. It was hard to get it to fit on a page, and maybe I shouldn't restrict it to that. But earlier when we talked about submission deadlines for the different types of cases, I was thinking that this was one place where it could go. And potentially on the right-hand side where it has authority, there's a lot of white space there. Maybe we could put in submission deadlines and what they are.
Doesn't that confuse the information? I mean, there's a clarity to it's just doing one thing.
Okay.
Because I think, people are always asking me, why is it this way and not that way? And this is about as clear as this thing could get visually.
Okay. Am I the only one? Okay.
I agree with Phil. I think it might make things a little more muddy.
And I agree. It seemed this would be one place that you might go to look things up. The other alternative would be to have a separate chart.
Yeah, that's what I would suggest.
Okay.
Just keep it simple. The KISS rule.
I like the clean. It's clean and simple as is.
Yeah.
Just for the record, Ed, give me an idea of what you were thinking to go in that margin.
It would basically have whatever the submission deadlines for we have. I think it goes better as a separate chart. I'll see if I can't come up with something.
Okay.
Because thinking about it is there was the cases where we want them to submit materials and when the signs are posted. I would just like to see that called out someplace. So
sure.
Just have the same format and just have the other thing that's on the right be different information.
Okay.
Yeah, maybe instead of the authority column, put time, time element, time schedule.
Okay, we'll see what I can do. So 105, our favorite types of case.
Hmm.
The first part was all, there's no changes from the existing rules. Any comments? So moving to hearings. So with everything else that we've done, this was the one substantive change that I think that we could make and still have it be quasi judicial. And if I understand from talking with Mr. Moore, this is actually allowed in the current procedures. It's just it's very rarely used. But if we could encourage people to use this time instead of then they don't have to be wait till when the opposition case starts and then they're treated as witnesses. So it's trying to make it more friendly to people that just want to testify and are not uh, I don't know, of informal opposition to, I guess, is a way to put it. I don't know. Phil, do you have any comments?
I think this is pretty clear, because obviously that does come up because people would stand up and say, well, can I testify? Or, you know, so having a statement that I think clarifies that when you're an individual and you want to make a statement. I think it
Kevin?
works.
Oh, sorry, Phil, were you going to say more?
No, I said I think it works.
Kevin?
Yeah, it works. Works for me.
Okay. Erica? Tootie?
Yes, I like it.
Okay. Tootie?
I think it works, but does Mr. Moore have a comment? Is his comment,
It's on the right.
does this mean that this particular, your change is in compliance? I'm not sure. I mean, if Mr. Moore could weigh in at this point to let us know exactly what he's getting at here, does he have, I mean, I imagine if he made these comments here, there's a reason for it. And I don't know if it's addressing your change, Mr. Coleman, or how about, can we hear from Mr. Moore?
Sure. So what's there right now as Section E, which I presume is what you're asking about, I think is legally fine. The discussion the chair and I had, the comment I had was, as I understood it, there was a desire to enable the public to have their say as easily as possible. What I pointed out is that when they testify under the County Administrative Procedure Act, they have to be under oath and they have to be subject to cross-examination whenever that occurs. The rules you have already do provide an opportunity for opening statement. So to the extent that a member of the public, and that's the part that I think the chair was mentioning that really isn't utilized very much. You don't see many opening statements in your quasi-judicial hearings, particularly from members of the public who are in opposition. And so as I understood what the chair was pointing out is that you often reach their testimony and they've been waiting for a long time to weigh in. They could make an opening statement and let you know what evidence they intend to put on and what their position is in general. Now, their opening statement isn't evidence. So if all they provided was an opening statement, they wouldn't have a case upon which you could rule in their favor. But what's present under E is legally fine. I don't know whether E accomplishes exactly what the chair was intending or not. I'm not saying it doesn't, but it's legally fine. My comments were, I guess, almost in response to the chair's comments, because as I understood it, he wanted the opportunity to provide public testimony that might not be subject to cross-examination. He wanted to give them a chance to speak their piece, but then not have to be questioned necessarily, because you do get a lot of folks who just want to say something, but don't necessarily want to involve themselves extensively as a witness. But under the County Administrative Procedure Act, if they want to provide evidence by testimony, the person giving the testimony is going to have to be under oath and subject to cross-examination.
So that means what you're trying to accomplish here, Mr. Coleman, really isn't applicable in the quasi-judicial format. Is that correct, Mr. Moore?
I'm sorry, my comment is not in relation to it?
No, Mr. Coleman is really trying to provide the public with an opportunity to just give their testimony without being sworn in. And what you, as I understand what you just said, is that if we're in a quasi-judicial, they have to be sworn in and they have to be subject to cross-examination.
That's correct. Under the county administrator, yes.
So then it does appear to me, based on what you just said, that this provision that Mr. Coleman is working to provide the public is not suitable here, seems like to me. Is that correct?
From my point of view, that's a fair statement. I don't want to speak for Mr. Coleman.
So where I disagree is I think that what Mr. Moore has stated is that this would not actually be, it would not be evidence, and it would not be subject to something that we would be able to base our decision on, but it would be a chance for the public to provide input as they do for a lot of our other cases. And that then the rest of the case, as the case unfolds, these issues would either be addressed through witnesses and testimony, or we would just move on. And for them to make a statement about the issue.
If I could interject here, there's a case in particular I remember where what Mr. Moore is describing would have been very helpful to residents, because their concerns, it was about a property subdivision, the concern was about water runoff and school allocation, and they were very, very upset about it, but it wasn't part of what we were actually deciding, but it was part of the issue as the community saw it. And it seems to me that if you could have something, it's almost like in our community meetings, we have resident speak out where people can come and speak, usually relevant to what's being decided at that time, but not part of our discussion. I think it's interesting to have something at the beginning for people who want to make a statement that can't be kind of shot down by the opposition too easily.
Well, the board's rules do provide right there at B for opening statements of parties. It is true that, at least in my experience, that's often utilized very little. But certainly members of the public could make an opening statement, and generally speaking, what one does with an opening statement is indicate, here's my position, and here's the evidence I'm going to present to you as this hearing occurs, so that you'll agree with my position. So they do potentially have that opportunity at the very beginning of the case, not subject to cross-examination, to speak their piece about what their case is going to be. Now, as I noted, if they never actually put on a case, if they make an opening statement but don't call any witnesses, give any testimony, or admit any exhibits, they will have expressed their point of view, perhaps, but not in a fashion where the board can make a decision based upon that point of view, because they won't have put in any evidence from which the board could decide in their favor. But if your goal is to give them the chance to say, here's what I think you should grant it, or I think you should deny it because the facts are all going to show it's a good idea or a bad idea. They can certainly do that in opening statement. And that might satisfy them. And that's permitted under your rules now. If you want to emphasize it so that people do it more often, you certainly can, but it's provided for under your rules now by 2B opening statements.
So I would assume that the general public would not necessarily take the opening statements of parties to mean that would necessarily, I'm not sure that the layperson would think that is available to them. Maybe we need to elaborate on that a little bit and incorporate maybe some of Mr. Coleman's intent here at B, item B. What are you thinking, Mr. Coleman? Are you muted?
CD, so it is. I think actually C, D, and E should be sub-bullets under opening statements of parties. So it'd be 1, 2, 3.
Would the opening statement would be first for public testimony then?
So this order would preserve what we currently have. The petitioner would go first and make their case of what's going to be presented tonight. If there was formal opposition, then they would have a chance to say why the petitioner was wrong. And then general members of the public that aren't part of that formal opposition would then have their opportunity to speak here, was what I was trying to convey.
My only concern, if I may, I guess that I do have one caveat to E, to the extent that you're suggesting that the E public testimony won't be under oath and won't be subject to cross-examination, then I do have concerns, because it really can't be testimony. They can make an opening statement. They can express their position in their opening statement. If their opening statement is going to be done in a different place in the case other than the very opening, that's fine. In fact, sometimes parties choose to reserve their opening statement for the beginning of their part of the case. In other words, go ahead and let the petitioner put on everything. And then when we get to the opposition, I'm going to start with an opening statement, and then I'm going to put on evidence. But if what you're intending to do here is to divide the time after the petitioner into formal opposition, who puts on witnesses who are under oath, who it submits exhibits, and then other people who get to express points of view, I think you can effectively let those other people speak at that point, but it's not testimony, because testimony is a form of evidence. Testimony needs to be under oath and subject to cross-examination. You could accept public statements, maybe you could call it at that point, as a substitute for their opening statement.
Okay, I was thinking if we deleted public testimony and then just said individuals wishing to provide opening statements to the board without joining.
Yeah, something like that I'd be very much in favor of, because it has been very upsetting to me personally to have the opposition attorneys just shut down people from the community because it wasn't what we were deciding that night. It wasn't the part of the criteria. And it seems to me, it seems to me that you can do it if you put it up in opening statement and just tell people what opening statement, what they can say.
Right. And the other pitfall I was trying to avoid is if we move this later, then we start with the witnesses, people come up and the witness talked about landscaping and they're there just to talk about school crowding. So, you know, they want to talk about what they wanted to talk about, and this was to give them a chance to do that earlier on.
Yeah, I mean, I think that'd be a worthwhile thing so people can understand that. Because opening statement, if I was coming to speak, I think opening statement is what the lawyers and the opposition groups are doing, not me as, Joe Citizen. So this kind of explains what you can do at that point.
And if possible, it would probably, I don't have a problem with the spirit of excluding immaterial matters or unduly repetitious statements. But if you could stay away from the word evidence, it would be good, because none of these statements are going to be evidence, because they're not being provided under oath. So you may want to say something like, shall exclude immaterial statements or matters, and may exclude unduly repetitious statements is good. That's fine. Or you could say irrelevant material. Didn't want to say immaterial material, but
Do you want
I like irrelevant material because because if you say I'm against this because this other property up the street, all the water came down the hill, to me that would be irrelevant.
Right.
If you say it's coming through my property, it might be relevant.
Yeah, or the example you gave of they want to talk about the schools, even though that's not on a given case, isn't part of the criteria that the board is empowered to make a decision based on. It's irrelevant to the board's decision because the board can't make a decision based upon whether the school is open or closed in that case.
So would it be clear if somehow the statement was actual words that said, that it has to be, what we're supposed to decide on? I don't know a way more concise to say that, but sometimes irrelevant can be in the eye of the beholder. Yeah, I mean, I understand legally what we're talking about and what we have to base our decision on, but somebody that is directly impacted by something probably thinks it's highly relevant.
But in this case, just say an opposition attorney could not shut this person up if it was an opening statement. Is that correct? They couldn't say objection.
You can object. It's sort of seen as discourteous, generally speaking, to object unless absolutely necessary in another party's opening statement. But you can. I mean, if they're making an opening statement about something irrelevant, you may feel the need to object for fear that the trier of fact is going to be distracted by irrelevant discussion.
Is Is it okay to have the word statement 4 times in one sentence?
Legally, yes.
Legally, yeah.
I mean, I get what the chair is asking about, and I suppose what you're suggesting is that the statements should be focused on matters related to the board's criteria. But of course, again, what people think is related to your criteria tends to be in the eye of the beholder, and they think whether the school is open or closed is very much related to what you're deciding, even though you look at it and say, but that's not one of our criteria on this case.
I agree. I think this really was the place where Mr. Coleman in particular, but all of us were feel that, the public who want to participate in the process, this is really where that would go.
Mm-hmm.
And we go for under B, right? Under B, Tootie?
Under E, which would be individuals wishing to provide opening statements, because they're not going to be sworn in and they're not going to be cross-examined. And so this would be people that really do want to participate, may not completely understand the ins and outs of the particular process, but will just be able to be heard. And sometimes that's really very important to them. And again, I agree with what everybody has said. Relevancy is kind of a personal thing. So this is the place, this provides that opportunity for them.
Okay. Doesn't need a heading then.
If I could suggest, I don't know if you want to, but you may want to at some point, maybe at the end of the section, point out that these statements, because they're not evidence, can't be the basis for the board's decision. Now, maybe that sort of undermines the purpose of having them speak, but my concern is that these same members of the public may think, wait a minute, I talked at your hearing. Why is somebody telling me that the board couldn't base its decision on my statement? Except because they would presume, well, I spoke in the hearing, they can base their decision on what I told them. But because they're not under oath and not subject to cross-examination, it is not evidence. And you could be persuaded by their statement, but you can't base your decision upon it. So in other words, it's basically argument that they're making.
So could there be something in when the description of what you can do is said these statements are not
evidence.
Not evidence.
In parentheses right now, right after cumulative in nature, put it in parentheses.
Because you said sometimes the neighbors just want to say something publicly, and for good or bad, our planning board is a public forum of sorts. I mean, all you have to do is see what happens when there's something that really gets a community juiced up. You can fill that room. So that it does have that role, and it would be good if there was just a way to kind of slot that in. And I think, these statements are not evidence. And I think that's pretty damn clear.
So actually, but wouldn't it be better if it said these statements will not be used as evidence for the decision?
Yeah, really. That's just a better.
Will not be used as the basis for the planning board decision, or just will not be used as evidence for the
decision.
So I have a question for anybody. So, will the public and will the flow of this particular process be clear to anyone in the room who is providing opening statements and who is going to be testifying? How will we define those particular portions of the evening? Mr. Moore?
Could you repeat the question? I'm not sure I got it.
So I'm looking at this as we move forward to E1, each person providing testimony, et cetera, will provide, name, address, et cetera. So prior to this, we have individuals wishing to provide opening statements, and then we have each person providing testimony. That could be very confusing, and I want to see if we can sort of get our heads around, perhaps with your help, how will we run this meeting so that the audience is clear who's providing opening statements and who's providing testimony.
I think it's a fair point, and I'm not honestly sure. I mean, the way the hearing is structured in this draft right here is the normal staff presentation, opening statements of the parties, which in this case is is going to be the petitioner's lawyer and then maybe an opposition lawyer where there is one, maybe a leader of a community group where there's an organized opposition but not a lawyer. Petitioner's then going to put on all their engineers and their salesmen and all the other people who they call to testify. They'll be subject to cross-examination. They'll rest. You then get to the opposition. The way it's structured right here, it appears to be that the entire opposition formal case would get put on. Whether it's a group organized behind one layperson or whether it's a group organized behind a lawyer, they're going to put on witnesses, they're going to admit exhibits, they're going to be subject to cross-examination. And then based on the way it's written here, you would then reach the opportunity for other people who want to make a statement.
No,
some of those folks may have already testified.
No, but the witnesses, as in the rest of the case, follow this, are not before this.
Well, then you might want to switch E and D as they're currently written, because as I read it, D is the opposition case. Or is that the opening? I don't have the rules open in front of me. I'm just looking at this little screen. Is that the opening statement? Petitioner's opening, opposition's opening?
Yes. So I think these should be 1, 2, and 3 under B.
Right. Yeah, that would be clearer, because I was confused by the fact that petitioner and opposition were broken out from opening statements.
Right. So
yeah, I think that makes more sense the way it is now.
Yes.
Did it?
And the bit about oath, just to clarify, that was when it comes to being the witness, witnesses are sworn in. I don't think there's any swearing in at this point, but we should have the same as we do for meeting testimony. The person state their name and at least relative location to the property, or their name and address, right?
I agree with that totally.
So that's where that sentence was trying to put that in there.
But this is saying that each person providing testimony, and we really separated the public out between statements and testimony are two different things. This is a little bit confusing.
But so we change it. So now it would be each person providing a statement.
Okay. I like that.
Does this apply
So do I.
to the individuals, the oath, or now the...
Yeah, it doesn't have to be oath. It was. And just kind of a nit for the first sentence where it says individuals wishing to provide opening statements. Could we just make it? Could we delete opening and just make it statements?
I do think you have to be consistent there, because you start with opening statements and then you sort of drop the opening as you go along. So one or the other.
Yeah. It does help to make sense that the first thing you say opening.
I mean, it's already under the section on opening statements, so the statement they're making is implicitly an opening statement anyway.
Okay.
So I have a question. Do we envision that the chair would maybe as you're running this particular meeting here under these rules, be able to say that, we're going to have the opening statements of the parties, then the petitioner, then the opposition, then the public will have an opportunity to make their statements, so that they kind of get the idea of how the meeting is going to be run, and they're just not sitting here listening and not having a clue when they're going to be afforded an opportunity. Does that make sense?
Yes.
It really does, Tootie. Yeah. Just like we try to explain the quasi-judicial, which everybody gets that puzzled look in the audience.
And for the mechanics of it, we should probably have the sign-up list, the sign-up sheet. It would be the sign-up sheet in the back if we were in public, or however you sign up to do this virtually.
So if you're saying a sign-up sheet for the statement and then also for testimony, two separate sheets?
Yes, yes, or one sheet where it has a block if you're providing a statement, or if you're formal opposition, if you're going to participate as a witness.
Sure, that makes sense. One sheet, and you identify what you want to do. Maybe a checkbox. I'm going to do this, or I'm going to do that.
And then I think, like as Tootie said, then the chair would have to explain, because we know some people are going to check the wrong box and
be there forever, right? You know what I mean?
Well, and you're gonna have, obviously, because you're talking about draft new rules, if these are adopted, even beyond folks who pay attention to your amendment of your rules, there's going to be there's going to be a learning curve here where you're going to get folks who are going to come in and say, I know I want to say something about this case.
Mm-hmm.
Which role am I supposed to have? And there's going to be a learning curve as you have to explain that there is this new option where you can put on evidence, including your own testimony or the testimony of other witnesses you call. You could admit exhibits. But if you don't actually want to put on a case, you just want to make a statement to us that we won't base the decision on, but you want to make a statement to us about this case, we've created this separate role for you. And you're going to have to walk people through that, because people are going to come in the first few times and, now, which one am I?
Right.
Am I both?
You hear that, Mr. Coleman?
Not at all. I just heard this buzzing noise. I don't know what you people are going on about.
Mr. Coleman wants to set up a separate role for the chair. He has a different...
Exactly, Mr. Moore.
Can I ask a question? Will everybody, when they give an opening statement, have to take this oath prior to their statement?
No, people making an opening statement aren't under oath.
Okay.
Oh.
As much as there are people who want to put most of the land use bar under oath before they give opening statements.
So, and I do understand that this might be confusing, and we will have to walk people through it. But I think part of it is almost a natural flow of the way people wish we were acting. So it might be a little bit easier for them to participate in. At least that's my optimistic hope.
By taking away,
I do think it sort of speaks to some of the concerns that I know I've had, and I've heard feedback from people, sitting out there, when they feel like they're being censored, or they're being kind of led around by the attorneys or whatever. But this kind of separates a certain place for the public to make a relevant statement.
You are going to need, Mary, to put back in at some point the oath, though. It got taken out here for purposes of the testimony section, because it's just an opening statement, not the testimony section, the opening statement. But there was a reason that oath section was in there. There still needs to be some description further down in these hearings of that oath requirement for witnesses.
This oath right here?
Oh, did it get moved up there, or was it repeated before?
It was just repeated. Mhm.
Ah,
Yeah, so now D1 is oath, and just clarifies
Right.
any individual testifying will have to take this oath. And then the next step is order of presentations. And then you have the introduction of reports by DPC staff, so I presume that means they don't have to take the oath. Opening statements of parties, the petitioner, opposition, and the individuals. I guess none of them have to take the oath yet. But then when you get into the petitioner's presentation of witnesses, that's when I guess the petitioner and all the witnesses would have to take the oath. Is that correct?
right.
Do you think where the description of the oath at the top, that there could be an additional sentence that said, individuals making a statement do not have to be sworn in, or something like that? Or is that just too much information?
What if it was changed so that oath came after the order of presentation? Or no, I guess not.
Or at the appropriate point in the order of presentation, because it's right now it precedes the opening statements, but you're never going to be administering an oath until you get to a witness.
Yeah, so remove it from number 1.
Put it in the, yeah.
And would you want it after the
For petitioners.
before petitioner's presentation?
Yeah, because it's going to apply to all witnesses, not just petitioners.
Okay.
Yeah, but that messes up. So oath is not going to be a number, because petitioner's presentation of witnesses should still end up as C.
Okay. You want that to be section C in order of presentations.
Right. And maybe we say witness oath.
Do you want oath back as in front of order of presentations and just clarify that
So
in section C, 1C is when the oath will need to be taken?
D.
Did that make sense?
Can you repeat again?
Yeah, if you still want oath to be enumerated under the conduct of board hearings, if you still wanted D1 to be oath, add a sentence that clarifies the oath will need to be taken once the proceedings reach section C.
I don't think it necessarily needs to be enumerated.
Okay.
So oath is not E, like Edward? Capital E?
Well, if anything, it would be
Conduct of board hearings is D. Isn't oath E? And then
Which would go just before.
and we're going up and down so many times. We're gonna have to open up another one. It sure looked like it was E. Looked like the last action was D. The next would be E. And then the next would be.
No, but so D is the overall conduct of the board hearing.
Right. Oh, I see what you're saying. So presentation, order of presentation, that's number one. Number two, do we have a two yet? Two would be the oath, administering the oath, right? If order of presentation, two would be the oath, and then three would be the actual petitioner's presentation of witness.
So I think if we just don't enumerate it, instead of saying oath, we call it, if we put the word witness in there, witness oath, all witnesses testifying.
Could you call it out? Could junk up the page, but you could call out an individual testifying that thing. Could that be in a box or something? So it's not, you're not trying to make it part of the procedure. It's just, it's explaining something that is
Administer. Use the word administer. Administer oath.
Which section are you talking about, Phil?
What I'm saying, where we have the green text for the oath, should that not, you're trying to get it into the outline format, but it should be like a box or something, like it is on when we have our scripts. There's pieces that are boxes that aren't part of the procedure, but just give you the verbiage.
I thought we were making a step-by-step instruction manual for the next board that comes on. It would behoove us to have it in some type of numerical order, but I guess you could put it in a box.
Well, no, I'm just saying information about what the oath itself is different than the procedure. In the other places, they're not giving you what words you say. With oath, it's explaining what the oath is. Period.
Oh, I see what you're saying. I see.
And then and then you keep giving the oath as you go through the next section. So it kind of goes from there on. You have to use the oath.
So why don't we move oath, the green text oath, under C, petitioner's presentation of witnesses, and then and then put oath.
I think that's a great idea.
Yeah, and it wouldn't be enumerated.
Yeah.
Yeah, I like that.
And then we probably want to repeat it for the opposition too.
Mm-hmm.
So it's not an enumerated step, but it is in order of as we go down through here.
Mm-hmm.
It's also handy for the chair when they forget what the oath actually is. They can look down and read it right off the screen.
Bill, you didn't have that before?
Yeah. Oh, yeah. Right. No. You have to flip the page back because after a while you get it right. But
that's if you remember to flip the page.
Yeah.
I like it in those both spots. That'll be
back when Phil was chair. You had to make your own oath.
I'll have to double check this formatting. Okay, petitioner's presentation of witnesses. And
it could be an italic too. I mean, just something to differentiate it from the flow of your outline format.
So then it would be here under opposition presentation as well.
Yes.
I do like the concept of the italics for this particular item.
Doing a wonderful job, Mary.
Trying to make these edits and track changes. It has a mind of its own.
I just find the whole formatting stuff to be a nightmare.
It is.
Would we need to read both under rebuttal or sub-rebuttal?
They've already been sworn in at that point.
Good point. Okay, I'm not trying to be busy. Where else would you like to go with this right now?
I'm satisfied with the way that it is. Anybody else?
That's fine.
I think it's good.
I keep scrolling through the decision in order.
Sure. I don't think any of the rest of this stuff has changed. Does anybody have any changes they would wish to make? Or even just comments of where any of this stuff has caused problems in the past?
I think our main problems were, or our main difficulties were the dates, timelines, when people submitted things. Um,
There was an additional comment in here that was incorporated from when you received public testimony on the previous procedure revision. Can everyone see that? Yeah. Zoom in.
So I thought part of this was considered unworkable. Like if it's a ZRA, it's certain things are county-wide. They're not like an individual property. I mean,
CRAs are changes to the county regulations. They inherently have application that isn't limited to one particular property. Factually speaking, there might be a property that is affected or is foreseeably affected, but they have countywide application.
so what was the major difference between the ZRA postings and what we're accustomed to seeing for planning board?
Well, I think that the HCCA concern was that if I'm the next door neighbor of a property that is the motivating factor for ZRA, but there's no sign on that property, then maybe I don't realize that there's a ZRA going through that relates to this property next door to me. The issue, however, is that the ZRA isn't, legally speaking, just about that property. That property may be what motivated somebody to say, hey, we need to change the county zoning regulations. But the zoning regulations are the county zoning regulations. They apply to the entire county. I mean, obviously, every zoning regulation doesn't necessarily have an effect on each piece of the county. If you change the zoning regulations that apply to Newtown, they don't apply to other districts. But they do apply to the county as a whole, anywhere there happens to be a Newtown district. But as I understood it, the concern was, if I'm next door to a property that's the motivating factor behind a ZRA, that how come I didn't see a sign on it?
Good point. It could change overnight and they wouldn't know about it.
But I thought the county position was, in Newtown would be a good example. If there was a ZRA to change Newtown zoning to something, where would you put that sign? Do you find the geographical center of Newtown and that's where the sign has to go?
I bet somebody knows that answer. I don't know what it is, but I would love to know what the geographical center of Newtown is.
And then we could argue that it was 5 feet to the left of where it was supposed to be.
It's your house, Mr. Coleman.
Yeah, well.
All distances are measured from there, actually.
No, I think that's an excellent point of excellent description of the legal issue, which is there is no particular place that the regulation applies to, unlike a land development request. You know, a site development plan is about this site.
I do think that Mrs. Gowan has an excellent point here. We should incorporate this because I do think it's important to notify the surrounding area. I do think that I think her suggestion is a good one. See if we could incorporate this. She's
not suggesting that we incorporate it. What she's indicated here, that this is a request from HCCA.
Oh, I'm sorry. Yes, you're right. So if they're suggesting that they put a sign, on the property and direct those who can see it to refer to the website, etc. Correct? For further information.
The question is which property is the property is the issue. What property gets posted for a ZRA that has countywide application?
So this must be a grander problem then, because I guess maybe people are required to just kind of occasionally just look and be informed about what's happening at planning board then, if so, to be completely informed about what's happening. That's correct?
It's a trick question. There is no right answer.
Yeah.
Currently, what's in section 1.106.b? That's what we're looking at now, right?
No, we're in 106.
Oh, okay.
Here's the notice to the public.
So I understand and I sympathize with the sentiment behind this, but I don't know how it can legally be enacted. Is my hesitancy to recommend putting anything in here.
I am with you, Mr. Coleman. I believe at this point we are doing as much as we possibly can for matters of zoning. If it's a development, that's one thing, but zoning, I think that one particular case that I recall where that came up, I don't know if there was anything else that could have been done.
Phil?
Yeah, I think where the sign exactly is, I mean, when you drive around, sometimes there's a verge on the side big enough to put a sign that everyone can see when they move up and down the road. sometimes you're stuck on the corner. So it's yeah, I hate to say the word archaic, but you know, I don't know. I had to do a change in a property that I have in New Jersey, and I had to send a registered letter to everyone within a certain distance from my property. But you know, the argument of where the sign actually is, I think, is really tricky. You know, like there's these signs that are around that have been there for months and months and months, and they weren't taken down. Well, that's confusing to people who live in that neighborhood too, I would think. So, for putting language in here that would straighten that out, I don't. I think I agree with you guys. I think it's a little too confusing for us to try to figure that one out.
One thing that may also be worth noting is that the existing 1106B is about notice to the public, in particular, for publishing the planning board agenda. So it's just your notice of your meetings. And Mary, you can correct me if I'm wrong, but most of the posting requirements related to land development approvals and ZRAs as well are in the county code. They're not in the planning board rules. In other words, what posting I have to do before I go to the planning board or the zoning board when I'm seeking a site development plan approval or subdivision approval is in the subdivision and land use regs, isn't it?
There are, I think, some posting requirements for ZRAs in the zoning regulations. But I think that people want to be notified when there is a ZRA coming before the planning board. And you clearly can't post it on an individual property because, as everybody said, it impacts an entire zoning district. So how can the public be better notified that there is a ZRA other than by going to the planning board website? So it sounds like they want the planning board to take responsibility for that. And I guess I have to look at the zoning regulations to see what those notification requirements are for a ZRA.
But I guess what I was asking, I think the board's rules right now are applied to how the board requires the public to know about the board's business. Not necessarily matters that come to the board. The matters that come to the board have posting requirements related to how you get that approval done. I don't think I'm being clear here, but I just noticed that 1106B in the current rules is actually about the board's agenda. So I suppose the board agenda requirements could be different when the board's agenda includes a ZRA. And what they have here, I'm not saying it's legally a good idea or a bad idea, but it occurred to me that what they're actually proposing here is that you identify the property that has to have notice of a planning board hearing about a ZRA. It goes to the petitioner's property. Now, which property, I'm not sure that clarifies. I mean, there's no guarantee that the petitioner has one property. And also, some of the ZRAs that come through they're not a property owner. They may be, sometimes they're a council member.
That just brings me back to are our rules and procedures, do we have to get, I mean, the signage thing, it sounds to me is coming from zoning and not from us.
Right. I mean, normally the signage is, they do have to comply with the signage requirements in the county code.
But we're not responsible for them. The planning board is not responsible for them, correct?
I mean, it's kind of a precursor to getting to you, but your rules, at least as they're currently written, address how people learn about your meetings, not about how they learn about a pending subdivision approval.
Right. So I think additional language trying to deal with this problem is more confusing than it is right now.
I mean, given that this is a comment by HCCA, I don't know, but they may well choose to participate in your public hearing on your rules. You could, whatever you want to do is that you find appropriate is fine. You may want to discuss it more with them then you may hear from them, and you may want to dialogue with them about how they could or couldn't be done. I mean, I presume they're going to testify anyway.
This is Lisa. David, may I intercede for just a second?
Of course.
I do know that HCCA's comments were forwarded to the county council because the biggest issue is how they're notified of the county council. Because the planning board's only making a recommendation. They are not deciding that ZRA. And I agree with the board. I don't know that there's any correct answer. Unfortunately, the ZRA, an attorney may come and argue a specific property in favor of that ZRA, but like David said, that's for an entire district, not for that property.
I think we should just leave it as is and let's see what the public says. I don't really know that there's much we really can do about it here. I think Lisa's information was very helpful.
I agree, and it'll come back up again where we redirect. We can do so. Actually, might be easier through conversation.
Otherwise, I could see us driving around with a station wagon, putting the signs up. I just can see that if we get too involved in it.
We're just put it at Ed's house.
So would this be easier to follow instead of cross-referencing if we just actually put the paragraph in there?
For what
I think we
paragraph?
should wait to see what it's going to come up in discussion.
No, I'm saying instead of having it say as required in section 1.106.b, we just took the text from B and just pasted it in here.
It was a long paragraph, wasn't it?
Yeah, okay. Electrons are cheap.
I would actually like that approach, but it does make for could be an unwieldy document. I mean, the other thing is to have it all in the back, the section.
I think more information is better than none. Would be helpful, I think, to people who are looking for that. I mean, if this is applicable, I would go ahead and repeat it. That would just be my suggestion.
Well, maybe if you're referencing a zoning thing, maybe that in the back, just like you do in a paper, you'll go to the bottom and then the references are in the back that you're using. So a layman wouldn't have to go get the actual documents online or from a hard copy.
So yes, I can copy it or not?
I think it won't hurt.
Kevin?
I was fine with the reference, but yeah, if you guys go with that, it doesn't make a major difference. I do agree with the others that stated it before me that I believe when we put this out for public response, I think it would be great to see what HCCA can offer to us to help us with this. And if anyone ever watches our deliberation on this tonight, they'll recognize the fact that we did open it up for public discussion. But we can go ahead and put it in there, and then we can always take it out also.
But keep in mind the HCCA is not. I say keep in mind the HCCA is not the. Somebody's. I'm getting feedback. I said keep in mind the HCCA is not the only body that gets to weigh in on this stuff. I mean, it's nice that they did, and I think we should consider their input. But it's a very large county.
So what are we doing here? Are we in agreement to just to cut and paste this, repeat this down at the other location and move on?
I would.
Kendall's making it happen.
Make it happen.
And somewhere in here, I have a general question about noticing advertising. Maybe it's the next section. I'll hold off. Well, no, because they reference it in places where we have that it says that it has to be published in 2 newspapers. Do we, David, do we actually have the authority to change that?
That's a good question. I haven't looked at the county APA on that topic. That would be the only reason why you couldn't.
I don't know, David. I'm a little iffy on that too, but it would be really nice if they would not be so archaic with that rule.
Because I would entertain discussion that electronic notification and having it on the website has more impact and is easily accessible than I guess it's the Washington Post now and the Howard County Times.
It's
Or-
actually, and you won't be, it's under 2106 of the County Administrative Procedure Act. At least 30 calendar days prior to a public hearing on any proposed, well, actually, this just goes specifically to adoption of rules. I need to look at the contested case section as well. At least for adopting rules, it has to be in 2 local newspapers. And it doesn't specify which. I mean, it's any 2 local newspapers of general circulation. Contested cases, contested cases require the agency shall give all parties reasonable notice of the hearing. It doesn't specify the, at least in 2111, it doesn't specify the publication. I don't know whether anything in the subdivision or land development regs does for different kinds of approvals.
So I mean, HCCA stated it here, and then we kind of repeat that language in section 1.109.
So you won't be able to take it out for your rulemaking hearings, but you don't do those very often. That's only 1.109, I think, right?
Okay.
There's nothing in the APA that I'm seeing for contested cases that requires it. Whether there's any requirements, like I said, for particular kinds of approvals, those wouldn't be set by your rules anyway.
And so, Mary, you might need to take a note for that where it has 1.103F.2. We probably need to cross-check that reference. Well, actually, all the references need to be cross-checked. So.
Just, did you want staff to cross-reference those sections?
Yeah, once we get the final formatting done.
you want me to continue on?
Yes, please. Scroll faster. The yeah, we're at the end. So other than scroll back up to the 109. So where it has the two newspapers right now, we're bound by county code to include that.
Yes.
Okay. Then that's I don't have any more comments. Erica?
I do not have any other comments at this time.
Tootie?
No comments.
Evan?
I just wanted to state for the record that I believe all of us have done everything we possibly can to make the rules of procedure a excellent guidebook for future planning boards and also for the public to be able to relate to what they are going to be doing when they arrive at a planning board meeting.
Yeah, I agree. Phil?
This is easy, and I totally agree with that statement, Kevin. You guys have been very thorough.
Well, let's not forget Miss Kendall, the magician. Excellent. Excellent. On the fly, too. Really good.
Phil, do you have any
Great job.
comments?
Great job.
Okay. And Mr. Moore, do you have any other outstanding concerns at this point?
Not to come to mind, no.
Okay. Mary? So I guess the next step would be we would get this reformatted and cross-checked, maybe add some additional items to the glossary. I don't know if anybody has any suggestions of what would go in there that they would want to forward. And I'll work on seeing about coming up with the table of at least a table for a placeholder for the timelines and submission stuff that we had talked about. And maybe we could shoot for a draft for review ready like towards the second meeting in January. Would that be okay, or first meeting in February? Or January 5th? I mean, speak up now or it's going to...
Not the 5th. Whatever's easier for planning and zoning to get done. I'd say, towards the end of January, early February, my thought.
Yeah, I like the idea of the first meeting in February. And then if there's a rough draft floating around that we can look at prior to that, that maybe, but I think that's an adequate amount of time.
Mm.
But January, because it's coming, even we're all going to have an odd holiday. It's still a holiday in the middle there. So it seems to me that February would be a better deal.
Can I just confirm that we're going to get this to you for final review before we advertise it for testimony? Is that correct?
Right. We get one more shot to look at it. And then
Okay.
what I would think is we would look at it and then vote to accept that as the draft. And then once that draft was accepted, that's what would be posted and start the clock.
Okay. Just wanted to verify. Thank you.
And so what I'm asking for staff is I want you to have adequate time to do it. But I'm just trying to put a date certain on it so that we know that there's a deadline. Right. So whatever you guys are comfortable with, I'm okay with. I would just prefer a date certain. So Mary, do you want to pick something? Do we want to go with the first meeting in February?
Well, I don't know if there's much left for staff to do, because it sounds like the planning board is going to have one more review. I'll send back these track changes for everyone to see and review. And then if the planning board members have anything else they want to add, I guess we would discuss that at one more work session. Is that correct? And then
I would hope that we would present it in a work session,
Mhm.
but it would just be a review that there should be minor changes at that point.
Okay.
Mary, just a quick keep in mind, Amy and I both are out for a whole week, so.
Yeah.
I mean, you know what I mean? You'll probably be in charge most of that time, so just an FYI.
Yeah.
It might be a little bit.
Right. Yeah.
Well, Mr. Coleman, did you say that there were other things you wanted to add, such as timelines and so forth?
Yeah, but I'll get that to them before the first of the year.
Oh, okay. I mean, I'm ready to look at it whenever staff can get it done. I think it really is. I think that's really on your side of the table at this point. I mean, I can look at it anytime.
Where do we send nominations for the glossary of terms? To whom?
You can send it to me. I'll take care of putting it all together. Which I, by the way, think is a great idea.
And if you do that, would you CC me and Kevin, please?
Sure.
Thank you. So, Mary, first of February?
Yeah, I think that'll be fine.
Okay. And if something comes up, we can delay it if we have to, depending on cases and things. But I would kind of like a date certain. Thank you for all your attention and work tonight, everybody. I hope you have a nice holiday. Does anybody have anything else in closing?
Have a wonderful holiday, everyone.
I just wanted to say one quick thing. Thank you all. This year's been really hard. And I just want to say thank you for your patience with all this technical stuff that we've all had to learn on the fly.
You did a great job, Lisa.
Yeah, I think it's working pretty well. I'm amazed just how far we've been able to come with the tech. In fact, I'm starting to like the technology, which is not like me at all.
Yeah, not driving is pretty cool.
It's awesome. No driving. Yeah.
Thank you all for your partnership this year. It's been, gosh, can't think of another group that I'd want to go through this craziness in terms of a board. So thank you all. It's been interesting, but we're a good team.
Another group that I'd like to sit and stare at a computer screen with.
I can't think of another.
As long as you wear that Santa outfit, you fit in anywhere.
Yeah. I'll put my other 2 cents in. Thank you, Mr. Moore. Thank you, Ms. Kendall. I do appreciate your feedback and your constant your advice. And team, thank you so much for putting up with all of my antics all year long. Appreciate it.
Thank you, Kim. Could I have a motion to close, please?
I move we close.
Second.
All in favor?
Aye.
Have a nice holiday, everybody. Thank you.
Happy holidays,
Have a
everyone.
wonderful holiday.
Happy New Year.
Happy holidays.
Be safe. Take care.
Thank you, Lisa. Thank you, Mary.
You're welcome.
You're welcome. Good night.
Good night, everybody.
Mary, for your help.
You're welcome. Thank you, Lisa.
All of your hard work, because you've done
Yeah.
most of the work.
Well, don't worry. I'll be sending it your way.
Thanks.
Talk to you tomorrow.
Bye.
Bye.